everyone's ready. I'm moving to the second of my 4 areas on interpretation, and this is some remarks from or points from the general statutory context. Just first of all, to locate section 111 within the structure of the Act, you will see that after part 1, which deals with socio-economic inequalities and we needn't be concerned with, the essential structure is this, that in part 2, page 4 of the bundle, the statute sets out key concepts in relation to equality, and chapter 1, beginning at page 5, defines the relevant protected characteristics. They're listed at section 4, and they include, for our purposes, on page 8, section 10, religion and belief. And then chapter 2, beginning at page 9, sets out the core primary forms of prohibited conduct in the statute. They include, relevantly for our purposes, section 13 at page 10, we've already looked at. So the starting point and the foundation, the key concepts of the statute are the protected characteristics and those primary forms of prohibited conduct. And so referring back to the authorities on the purpose of the legislation, that is that those are the forms of conduct which it is the purpose of the legislation to eliminate within the spheres to which it applies. Then beginning with part 4 at part 3 at page 22, the statute contains a series of parts which make it unlawful to commit those various forms of prohibited conduct within the various spheres that Parliament has decided the statute should apply to. So, paragraph page 22, you see part 3 deals with services and public functions, and we don't have the full statute in the bundle for obvious reasons, but part 4 makes applies to premises, part 5 applies to work, part 6 to education, and part 7 to associations. So that's the structure of those parts, and it's at that point then that we get to part 8 at page 25 of our bundle, which is headed Prohibited Conduct Ancillary, and contains provisions dealing with relationships that have ended, liability of employers and principals for their agents and employees, and then conversely liability of, at section 110, liability of employees and agents, individual liability of them for the acts that they commit in the course of their relevant employment and agency, and then section 111. Also worth noting, section 112 deals with knowingly aiding contraventions at page 30. So section 111 appears within that part which is dealing with and conduct which is ancillary to primary liability. And I make 3 preliminary points in that regard. First of all, since it is explicitly a form of ancillary liability, the primary context which ought to inform the additional ingredients over and above but for causation must be the primary prohibited conduct to which this is ancillary. That's the context, that's the principal context in which this provision must be read. Secondly, it's apparent from the terms of the section itself what its purpose is. So let me just first of all emphasise what its purpose is not. Its purpose is not to deal with exploitation of the particular relationship that falls within subsection 7. That's a gateway provision, and the effect of subsection 7 is simply to say this form of ancillary liability applies where the relationship between A and B is one that falls within one of the spheres to which this Act applies, parts 3 to 7. So what it's doing is it is meeting the overarching purpose of eliminating the very great evil of discrimination within those spheres by ensuring that where someone, person C, is subjected to a detriment because of the interactions between two parties, I should say discriminatory detriment because of the interaction between two parties, A and B, that there is liability for any culpability within that interaction where all of those relationships fall within spheres to which the Act applies. It's quite difficult to put these points without sounding abstruse and academic, but to take the example I gave earlier, the point is, if I'm a supplier to company A, I have to not discriminate against company A, but I also have to not cause company A to discriminate against company A's employees, company B's employees, because both my relationship with company A, company B, and company B's relationship with its employees C are all within the spheres covered by the Act. So if I'm doing something which has all of the hallmarks of the conduct which the Act is trying to prevent, and I'm doing that in relation to B or C, and that causes B to discriminate against C in a but-for sense, then there is every reason to hold me liable, because I shouldn't be doing things that have all the hallmarks of discrimination within the spheres to which the Act applies. So that's the context that informs the provision, but it's also quite clearly from the terms and face of the provision, the purpose of the provision. Sometimes in the tribunal's reasons and in unlearned friends' submissions and in the AT's judgment, there's a sense that this is supposed to, there's an idea that the purpose is in some way exploitation of the relationship between A and B. That's not the purpose. That's just the gateway that says this is an area in which you shouldn't be doing things that are to be prohibited by the statute.
There must be a relationship between A and B.
Yes.
And a relationship between B and C.
Yes, by definition there has to be a relationship between B and C, because B wouldn't be in a position to commit a basic contravention in relation to C unless there was such a relationship.
But not between A and C.
Not between A and C. That's precisely, it's to bridge that gap. If A is doing things in relation to B or C in a context to which the statute applies, a sphere to which the statute applies, and those things are culpable in the Equality Act sense. Those things have the characteristics of discrimination at which the Act is targeted. So that's really the central point. And it follows from that, as I said to my lady this morning, that on the one hand, it would plainly be absurd and contrary to the purpose of Section 111 if person A could be liable in circumstances where he or she does not have, for direct discrimination, in circumstances where he or she does not have the relevant conscious or subconscious motivation. is not acting because of the protected characteristic. But on the other hand, it would be equally absurd and contrary to the purpose of section 111 if a person A were not liable in circumstances where their conduct had all of the characteristics of direct discrimination, and but for that conduct, C would not have been discriminated against. But there were found to be some intervening cause or some other feature that negated that liability. And I asked the rhetorical question, if one is not to find the features which may negate liability in the characteristics of discrimination, where is one to find those features in the context of this legislation? How is anybody to know what it is they're not supposed to do? How is any court to decide that this is something that the statute thinks is okay, that Parliament intended should not give rise to liability? The only possible source of those additional features must be in the underlying primary causes of action, the underlying main forms of prohibited conduct in Part 2, Chapter 2 of the statute. And to bring it right back to this case, I could pose the question rhetorically of the tribunal. If the answer, the tribunal's answer is this was just a protest, what are the characteristics of a protest that mean, having regard to the purpose of the statute and the context in which this provision appears, that mean liability is to be negated? And again, I go back to my point I was making this morning. This has to work for all the protected characteristics. Why is it that a protest about the protected characteristic of belief and its legitimate expression, which is equally protected, what are the features of that which negate liability? And that would have to apply equally to a protest about someone's race or about someone's sex. There are other features of section 111 itself which support a broad interpretation, and I've listed them. I won't trouble the court by going laboriously through them at paragraph 46 of my skeleton argument at page 32 of the bundle. The only one I'll just perhaps pick up because it's referred to and relied on by my learned friend is at the one that's mentioned at subparagraph 46.3 of that skeleton argument. Which is the provision in relation to inducement, that it may be direct or indirect. My learned friend, I think, relies on that and the absence of an equivalent provision in relation to causing under subsection 2 as implying that causation must be direct and cannot be indirect. And in my submission, that is neither what subsection 4 says nor what it implies. The purpose of subsection 4 can be seen if one goes in the authorities bundle to the Services Code of Practice of the Equality and Human Rights Commission, right at the end at page 834.
What are we in
The authorities bundle 834 paragraph 917. Where you'll see the point of directness is addressed. the inducement, in the second line, the inducement does not have to be applied directly, it may be indirect. It is enough if it is applied in such a way that the other person is likely to come to know about the inducement. And that draws on authority from the earlier case law in relation to the earlier legislation. For your reference, we need to turn it up, in the Commission for Racial Equality against the Imperial Society of Teachers of Dancing. You'll see the earlier provision at pages 33 and 34 of the bundle, the earlier provision from the Race Relations Act, which is to that effect. And so what subsection 4 is doing is making it clear, where it might not otherwise be clear, that an inducement may be applied by bringing it directly to the intention of the inducee, or via someone else in circumstances where it is likely to come to the attention of the inducee. So the effect of it is to broaden what might otherwise be the narrower scope of inducement. It's not saying anything about the scope of causation and whether causation may be direct or indirect, because there are well-established authorities for determining whether an intervening act breaks the chain of causation in relation to causation or not, and so the statute doesn't need to specify the position in relation to that. It doesn't imply anything one way or the other about the scope of causation and whether that need be direct or indirect, or how direct or indirect it need be. So in my submission, coming to then section 111.2, back in the authorities bundle at page 29, there are a number of points that may be made. First of all, the EAT was right, and I think it's common ground, that the term cause does not imply a requirement for any conscious motive or intention on the part of the person A, and that must be right because it would be inconsistent with discrimination law generally, C. Nagarajan, to require a conscious motive or intention. It's apt to cover unintended consequences, provided, in my submission, the relevant ingredients for liability are met. Secondly, the EAT was right to note that in identifying the additional ingredients of legal causation over and above but for causation, it's necessary to analyse the nature, purpose and scope of the obligation in question in order to ascertain for what the defendant or respondent ought to be held liable. The EAT was, in my submission, wrong to treat that by itself as supplying the test, because, as I've indicated, the duty bearers who have to comply with this legislation need to know what it is that they are and aren't allowed to do. And the effect of the EAT's approach is that in practice you wouldn't be able to ascertain whether what the duty bearer, what person A has done, meets the criteria for liability until you examine retrospectively what the particular causal relationship between those actions and person B's actions were. Just to take, or indeed other circumstances, just to take one example, but it's a striking one because it's within the same paragraph of the EAT's decision. Paragraph 123 of the EA's decision at page 71 of the bundle. The EAT says in the second line, liability for causing a contravention does not depend on a test of reasonable foreseeability. But then in the concluding sentence of that paragraph, no doubt foreseeability will often be a relevant area of inquiry, but will depend on the facts. So within the same paragraph, we have foreseeability not being a requirement, but often being a relevant consideration depending on the particular facts, but no indication as to what in those facts will mean that foreseeability is or is not relevant. This is an open-ended test on the part of the, proposed by the EAT, wholly untethered from the purpose of the legislation. Similarly, and I may need to come back to this, but I'll deal with it now. Similarly, the emphasis that the EAT places on paragraph 115 on the previous page, page 70, on the precise causal relationship between person A's actions and person B's response is in my submission unworkable, because it can lead to circumstances in which A's actions are precisely the same, and in both cases lead to person B discriminating in a but-for sense, but liability depends entirely on person B's thought processes. So what the EAT appears to be saying at paragraph 15 is that A's actions need to not only bring about the act of discrimination by person B in a but-for sense, but also need to be the direct trigger for the discriminatory thought processes of person B, which mean that the act is, the basic contravention is direct discrimination. And so you can have a situation in which person A makes a complaint to person B, making some reference to the protected characteristic and perceiving person B to share their prejudice. And in a situation where person B doesn't initially share that prejudice, but is triggered to share that prejudice by the complaint, person A is liable. But in a situation where person B already shares the prejudice independently, and that's because of their independent prejudice or thought processes, person A would not be liable. And so you, on the EAT's approach, you have this sort of metaphysical questions about the precise causal relationship between the mental processes of person A and person B, when on either view, what person A in that example I gave has done is something that it has all the hallmarks of discrimination. Person A has complained to person B because of the protected characteristic and caused person B to discriminate in a but-for sense as a result. So the EAT's approach is unworkable, and the only approach that produces a coherent and stable method of identifying the relevant ingredients is to refer them back to the underlying causes of action. That approach is also, in my submissions, consistent with authority. As I said, there's no authority on the particular meaning of section 111, but it is nevertheless relevant in my submission to have regard to authorities on causation in tort generally, because, as those authorities themselves make clear, the extent of the extent to which a defendant may be liable is not confined to liability or causation, but is a question about the overall scope of the duty and for what within the duty is the person liable. So even though in this case the tort itself is causing isn't the test for remedy, that the authorities are nevertheless helpful. The leading authority is Kuwait Airways Corporation and Iraqi Airways Company. It's in the authorities bundle beginning at page 69, tab 5. Can I just hit the core points by going to page 276, paragraph 69 in the judgment of Lord Nichols, where he identified 276, my lord.
Tab 6.
It's tab 5. He identifies that establishing the scope for which a defendant may be liable in tort calls for a twofold inquiry. First, whether the wrongful conduct causally contributed to the loss, and if it did, what is the extent of the loss for which the defendant ought to be held liable. The first of these inquiries, widely undertaken as a simple but-for test, is a predominantly factual inquiry. And then 70, the second inquiry, although this is not always openly acknowledged, involves a value judgment, ought to be held liable. So just pausing there, when my learned friend says this was a question of fact for the tribunal to find causation, the answer is no, it wasn't. It was a question of law and judgment. The tribunal had to identify the correct criteria by which to test whether person A ought to be held liable, and then apply those criteria properly to the primary facts it had found.
Which paragraph of the judgments in the Kuwait Airways case tell us that?
I'm sorry, my lord.
You took us to Kuwait Airways, or you announced that it is at tab 5, but I didn't get the paragraph.
Apologies. Paragraph 69 I read from, and then the first line of the first sentence of paragraph 70 I read from at page 277. So Lord Nichols goes on.
Your extra criteria come in at the second level.
At the second level.
Because you say it's part of the value judgment in this kind of case.
Yes.
Value judgments are different depending on which tort, which context, and which statutes.
Exactly that. And paragraph 70, Lord Nichols elaborates on the various different epithets that lawyers use to represent those value judgments, but notes in the end they are guidelines, some more helpful than others, but they're never more than this. And then importantly at paragraph 71, in most cases how far the responsibility of the defendant ought fairly to extend evokes an immediate intuitive response. This is informed common sense by another name. Usually no difficulty in selecting from the sequence of events leading to the plaintiff's loss the happening which should be regarded as the cause of the loss for the purposes of allocating responsibility. In other cases, when the outcome of the second inquiry is not obvious, it is of crucial importance to identify the purpose of the relevant cause of action and the nature and scope of the defendant's obligation in the particular circumstances. And in my submission, there's a bit of both in this case. In my submission, the instinctive reaction, informed common sense, ought to be that this is targeted at things with the characteristics of discrimination, but it's also an entirely unique statutory tort that needs to be read very carefully in the context of the particular legislation, and it isn't immediately apparent precisely from the array of epithets that lawyers use, foreseeability, proximity, directness, indirectness, which of those ought to be selected for these purposes. And so this is a case where it is of crucial importance to identify the purpose of the relevant cause of action and the nature and scope of the defendant's obligation in the particular circumstances. I note, but in view of the time, won't go to the application of that test in Esser and Lang. My Lord Justice Bean will be
To remember
familiar.
that one, yes.
It doesn't. The judgments in that case don't modify or develop this underlying test, but what they do is apply it in the context of the Equality Act, again having regard to the broad purpose and the need for a wide interpretation, in order to find that foreseeability is not a requirement generally for losses flowing from discrimination under the Equality Act. And then the other case, which in my submission is of real assistance, is decision of the EAT in Bullimore and Pothecary Witham Weld, which is tab 8 of the authorities bundle. This was a case where the claimant had left her previous job and compromised a claim for discrimination in relation to that, and then made an application to a new employer. The new employer sought a reference from the old employer. The reference gratuitously referred to the previous complaint, as well as being an unfavourable reference, and the new employer modified the terms of the offer such that the claimant decided not to accept it. So she sued both, settled against the new employer, the prospective employer, and pursued her claim against her former employer, succeeded on liability, and the tribunal then held that the prospective employer's intervening discriminatory conduct in modifying the terms of its offer broke the chain of causation. The EAT, with Mr. Justice Underhill, as he then was as president presiding, held that the tribunal had erred, and again, the red line passage on page 365 of the bundle, beginning at paragraph 15. The whole of the passages redlined are relevant, but I will focus, if I may, first of all on paragraph 18, the proposition that there is certainly no rule that the free choice of the subsequent tort fees necessarily breaks the chain of causation, and the same point in effect is repeated at paragraph 19. And then at paragraph 20, dealing with foreseeability, it's evidently foreseeable that the new employer, prospective employer, might react to the information provided by Mr. Hawthorne in the way they did, even if such a reaction would constitute unlawful discrimination. And if and insofar as this expresses a different concept, that such a reaction was a direct and natural consequence of the supply of information. The whole purpose of a job reference is that it should be taken into account when the recipient is choosing whether to offer the candidate a job. Negative or damaging reference, as the tribunal expressly held this to be, is liable to have precisely the result that occurred in the present case. To use the language of Dorset Yacht, it was the very kind of thing which was liable to happen. And then paragraph 21, standing back from the tribunal's reasoning, it seems to us that as a matter of policy and fairness, the respondents ought plainly to be liable here. When an employer or ex-employer gives, for an illegitimate reason, and I emphasise those words, an adverse reference which leads to a prospective future employer deciding not to make or to withdraw a job offer to a candidate, it is hard to see why that consequence should be regarded as too remote to attract compensation from the original employer. So far from being remote, it seems to us both close and direct. And then over the page, paragraph 22, our conclusion does not depend on Mr. Hawthorne, that's the individual giver of the reference, having positively intended that Sebastians should withdraw their offer to the appellant. It is enough that with the relevant prescribed motivation, he gave a reference which was liable to have that effect. So if one were to transpose those descriptive passages to the present case, in my submission, they fit like a glove. In this case, what Mr. Metcalfe did was, with the prescribed motivation, with the illegitimate reason to do something, make a complaint, which was the very kind of thing likely to be considered by the person complained to, and to lead them to them acting for the reasons given in the complaint. And what Bullimore indicates is that in this context, in the context of discrimination legislation, the relevant criteria for deciding whether or not something breaks the chain of causation, whether causation is sufficiently direct or not, whether it is fair or reasonable or just to hold the defendant liable or not, whichever of those epithets, those descriptions one uses, the criteria that are relevant are the illegitimate purpose, the prescribed motivation, and whether or not this was something liable to have the consequence in question. I don't put that in terms of reasonable foreseeability. Simply, was this objectively something that was liable to be treated in that way by the recipient? It does not require the intention of the person doing the thing.
Just going back, you say you're not saying reasonable foreseeability. That's different from liable to have the consequence. What's the difference?
Well, they may be close concepts, but I'm not sure I can articulate a difference. I think probably it comes to the same thing, that what one asks is objectively, so not based on what the individual thought or did in fact intend. Objectively, was this the sort of thing that was liable to be treated in this way by the recipient? And I should say, we before the tribunal and the EAT, we accepted that for the purposes of this case, reasonable foreseeability could be treated as part of the test because we said it was met. But we said you don't have to decide once and for all whether it's always a necessary part of the test or not. So those are the features which are relevant to whether or not a respondent ought to be, a person A ought to be held liable, and that's the proper interpretation of section 111(2) in relation to causing direct discrimination at least. And there may be other questions for other types of primary cause of action. This court doesn't have to decide all of those. So I've made my point already, and I needn't elaborate it. Both of the alternative tests proposed really just beg the question. If you take the EAT's fair, just or reasonable test, you end up asking, well, what are the criteria by which I decide fairness, justice and reasonableness? And the only way of finding a solution is back through the purpose of the legislation, which leads you back to the characteristics of discrimination which this legislation is designed to eliminate. Similarly, the test proposed by Stonewall of direct as opposed to indirect causation begs the question, what is direct and indirect in this situation, which leads you back to identifying what it is that means that someone ought to be held liable or not, and that leads you back to purpose, and it leads you back to the primary causes of action. So whichever route one takes through this, that's where you end up, and those are the criteria, and they give you a stable basis for everyone knowing where they stand. If a person A in a relationship with person B, a supplier or a provider of premises or a public service provider, if that person does something because of a protected characteristic which is detrimental, less favourable in relation to B or C, they will know that they are liable for the consequences of that in relation to B, and also if that causes B to discriminate against C. And that doesn't then change depending on the precise way that B happens to think about it or deal with it.
Right, where do we go next?
I will deal very briefly with inducement, but as you will have gathered, I put my case primarily on the basis of causation.
Yes.
Inducement is dealt with in my skeleton at paragraph, beginning of paragraph 59, page 18 of the bundle. It's common ground, I think, the point that I make in paragraph 59, that an inducement need not involve an element of carrot or stick, but may involve only persuasion or encouragement or something of that kind. And the reference to authority in relation to the predecessor legislation in that regard is given there. For your reference, the relevant passage is pages 33 and 34 of the authorities bundle. The second area of dispute in relation to inducement is whether or not person A must have intended precisely the basic contravention that in fact occurred, or whether, as in my submission, person A need only have intended conduct of the kind which in fact ensued. And I don't think I can put the point more crisply or more persuasively than the way it's put in that paragraph 60 of my skeleton argument. It's perfectly natural to say that person A induced person B, for example, to impose a disciplinary sanction where person B makes a complaint intending no more that it be considered, and person B then decides for himself what action to take. And given that the purpose of the legislation is a broad one, the broader interpretation should be applied, so that perfectly natural reading of inducement should be applied. And then the other elements of liability engage the same questions that we've already been through at length in relation to causation. So the relevant ingredients for liability in relation to inducement in my submission are: one, they're set out at paragraph 62 on page 37. One, person A acts because of the protected characteristic. Two, person A does so with the intention of persuading person B to take some action of a particular kind. Person B is persuaded to take action of that kind, and in doing so, person B directly discriminates against person C, whether or not A intended or brought about that specific discriminatory mental process or outcome.
Possibly going off to tangent, but when could inducing apply when causing wouldn't?
I don't know. I can't think. I've tried. I can't think of a circumstance in which it wouldn't.
Even in causing?
No, exactly.
Yeah.
I mean, It may be that it's there for belts and braces. It may be that it's there simply because it's more apt to describe some forms of action as inducement rather than mere causation. It may be that it's there to help with attempts, that an attempt to induce is an easier thing to think about than an attempt to cause. But I can't help more than that as to why there are distinct causes. And the only other point I make in relation to it is one that I've made in the skeleton, which is that what it does suggest, with the fact that these are obviously overlapping ways of committing the tort, is that they are intended to have a broad coverage. They're not intended to be narrow and mutually exclusive and confined.
In ordinary usage, induce doesn't necessarily mean induce successfully.
No,
It could be attempt to induce.
precisely. And the statute specifically provides that intent attempt to induce would be sufficient. But as you say, that's why it's perfectly natural to say, I induced so-and-so to do X, even if X isn't precisely what I intended, if nevertheless I did something intending to cause person B to do something in that nature. I think I can then draw the threads together through my final two areas relatively succinctly, which is simply to address the specific grounds in relation to, first of all, the ET and then the EAT. Before I do, can I just check it, but whether there are any questions that the court has on what I've said so far? Grateful. So ground one, perhaps I can do this most helpfully by reference to my skeleton argument. At page 37, paragraph 63, I'll address solely in relation to the tribunal, first instance tribunal here. The EAT really doesn't matter for these purposes, without any disrespect to that tribunal. Ground one follows, if you agree with me about what I've said in relation to what the correct test is, because on any view it's clear the tribunal didn't apply that test. Doing the best we can with what the tribunal has said, it probably meant that the chain of causation was broken and or the ingredients weren't made out because Kieran Medcalf didn't intend the specific actions of Garden Court, but for all the reasons I've said, that can't be a proper basis for establishing liability, insofar as the tribunal thought that the answer lay in its finding of mere protest. I repeat my point, what is it about a protest that would negate liability here? I'll answer nothing if one has regard to the purpose of the statute. Ground two is to the effect that even if I'm wrong about what the test is and the need to have regard to, in every case, to the underlying causes of action and the ingredients of those, on any view in this case, it would be fair and just and reasonable to hold Stonewall liable because of all the factual features of Kieran Medcalf's actions, which I outlined in the first main area of my submissions and are recapped in subparagraphs 65.1 to 65.4 of my skeleton argument, and so I won't rehearse those points again. If you agree with those submissions, which again essentially have regard to the underlying purpose of the statute, then it will follow that whatever the correct test, this appeal ought to succeed because the tribunal was perverse in not upholding the complaint, having regard to its own findings in respect of the relevant matters. And then in ground 5, again deals with the failure of the tribunal to apply the correct test in relation to inducement. It's clear that the tribunal based its dismissal of the inducement claim by primarily or on its findings to the effect that Mr. Medcalf was not intending to threaten damage to the diversity champions relationship, and Garden Court did not perceive such a threat in the complaint. Those, it is common ground, I think, are not the basis on which liability is or is not established in relation to inducement, and on any view the tribunal didn't apply what I have submitted is the correct test in relation to inducement. And so again, if you accept my submissions on the correct test, it will follow that the tribunal didn't apply it, and that had it applied it, it could only have found that the complaint succeeded. I do just highlight the alternative submission at paragraph 72 as well, although it may not add much in the end. But if one reads the tribunal's reasons as accepting Mr. Medcalf's own evidence as to possibly intending a statement dissociating Garden Court from the claimant's beliefs, if that were done in the terms of Mr. Medcalf's complaints, we find that your beliefs are transphobic and we dissociate ourselves from them, then on any view, that would be a detrimental act, unlawful discrimination against the claimant by Garden Court. So, on Mr. Medcalf's own evidence, what he intended was to induce Garden Court to do something that would amount to unlawful direct discrimination. And it's explicit in the statute. It doesn't matter if that thing happened or not. He is liable for, and Stonewall is liable for any detriment to the claimant that follows from that. So there are all of these routes through to establishing liability. That leaves me only with the additional errors of the Employment Appeal Tribunal. There are 4 of them. First of all, in terms of ground 3, the Employment Appeal Tribunal, this is paragraph 67.1 at page 22 of my skeleton argument. Employment Appeal Tribunal, having held that on its view reasonable foreseeability was not a relevant part of the test for liability, went on nevertheless to say, to hold that it was not particularly likely that Garden Court would discriminate in response to Stonewall's complaint. In my submission, on any view, that was both wrong and not a finding that was open to the EAT. The tribunal itself didn't expressly deal with reasonable foreseeability because it was not suggested to the tribunal that it needed to, but for all the reasons I've outlined in my submission, considering a complaint and acting upon it is plainly the very kind of thing that a recipient in the position of Garden Court is likely to do, and there was abundant evidence before the tribunal. Indeed, there's abundant material recognised in the authorities that I took the court to this morning, that all sorts of respectable organisations have been inclined to discriminate against people because of gender critical views where they disagree with those views. And the idea that Garden Court could not foreseeably have done so is not sustainable, particularly on the evidence before the tribunal, which the EAT doesn't consider or address, that Garden Court barristers had expressed views sympathetic to that of Mr. Medcalf throughout. The second additional matter that the EAT took account of that was outside its remit is at paragraph 67.2 of my skeleton argument, that Stonewall's complaint, EAT's view that Stonewall's complaint was itself a legitimate manifestation or expression of beliefs that are also protected under the Equality Act. With the greatest of respect to the EAT, that point is neither here nor there, because we are not dealing with a public expression of beliefs in the manner of the claimant's expression of her beliefs. Everybody is entitled to hold their beliefs and express them appropriately in a public way and not be discriminated against for doing so by their employer or other duty bearers. And that would apply equally to Mr. Medcalf if he expressed his beliefs on Twitter or in any other public forum. What the Equality Act prohibits is, within the spheres to which the Act applies, acting on those beliefs to subject other people to detriments. And again, that applies both ways. Someone with gender critical beliefs is not entitled, under the Equality Act, to complain to people with whom they have a relevant relationship that brings them within the sphere of the legislation about the public expression of pro-self-ID beliefs on Twitter or elsewhere. And it would be equally wrong for somebody with gender critical beliefs to do that, as it is for Kieran Medcalf to do that.
I understood, or I thought maybe the EAT was trying to get to there was to pick up on what the ET had said about protest. And there is one way of reading it, and we've been over there many times, and I've got your submissions on it. But if what the ET was trying to say is that it was merely a protest, in other words, it was just an expression of Kieran Metcalf's own view, that the EAT was coming along and saying, and what's more, he was entitled to express his own view. And I don't think you'd dispute that, would you? You'd just say it's by the by, to get to the guts of what your argument is anyway.
Exactly. It's by the by because he's not expressing that view to the world at large. He's expressing that view in a complaint.
Yeah, he was entitled to write.
Court.
I mean, he was entitled to write, wasn't he, to Garden Court Chambers to say, I put on, I don't agree with these tweets. I don't agree with what has been put out there by one of your tenants. That wouldn't be offensive, would it? You've got to go the extra bit, haven't
Yes.
you? I mean, I know we could then have the same debate in a different context, but there must be a point at which you are entitled simply to say, I disagree with your legitimate view, and it's my legitimate right to disagree with your legitimate view.
Yes.
And that's all okay, isn't it?
It is, absolutely. And I've been telling employers in talks for a long time that they have to allow their employees to express views within the workplace. So
if that's, I don't know, if that's what the EAT was doing, it doesn't really matter either way, does it? It's not on their critical path to their conclusions. So
no, it's not. I simply address it because it really, on any view, it wasn't a matter for the EAT. If it was a matter for anyone, it was for the tribunal. But as you say, it's by the by, because Kieran Medcalf was not merely expressing a view. He was indeed, on the tribunal's own finding, protesting about a protected characteristic. And we've been over the ground. He'd gone the extra mile. He was making the allegations of transphobia, etc., etc., and was doing so in the context of a complaint to protest. And then the third aspect that the EAT took into account, which wasn't a matter for it and wasn't open to it, I've addressed in paragraph 70.3 of my skeleton argument. The suggestion that Mr. Medcalf was not acting because of the belief itself, but because of an allegedly objectionable manifestation of the claimant's belief. The Court of Appeal in Higgs, as I said earlier, I'll give you the reference rather than taking you to it, affirms the proposition that in order to make that sort of distinction, you have to first find that objectively the manifestation was objectionable so as to justify restricting it. That's to be found in the Court of Appeal in Higgs, paragraphs 74, 78 and 175, subparagraphs 1 to 3. Page references in the authorities bundle are 724 to 5 and 752. And so the EAT was simply wrong to say that you can draw a distinction on the basis of something being allegedly objectionable as opposed to actually objectively objectionable. That wasn't a matter for the EAT, and it was a matter that the tribunal had determined in the claimant's favour and hasn't been appealed. So those three aspects of the EAT's decision are further errors on its part, all matters that were not for it, on which it weighed in when it ought not to have done. And the final error of the EAT, and this is my ultimate fallback position in this appeal, is that even if the EAT were right and the test was fair or just or reasonable in the open-ended way that the EAT has suggested, and potentially having regard to all of the things the EAT did, that was not on any view the test applied by the tribunal, and is on any view a matter which requires the application of judgment by the first instance tribunal. And so my ultimate fallback position is, even if you're against me on what I say is the right test and what I say is the right outcome, that there is only one possible outcome here, at the very least, if there is a different test, it wasn't the one applied by the tribunal, and the matter ought to be remitted. And again, the court will be familiar with the case of Jaffrey,
yes,
which makes that point, and the references in the skeleton argument and the cases in the bundle. My lords, my lady, would you just give me one moment? Unless I can assist further, those are my submissions at this stage.
Thank you very much. Ms. Oman-Bum.
My lady. The benefit of having listened to my learned friend take you through very many of the authorities this afternoon is that there are many that I do not need to trouble you with for the moment. What I would like to do, just at the very outset, is to give you an indication of where these submissions will take us.
Yes.
My lords, my lady, you will have seen from my skeleton argument that the respondent's position essentially is that what we have heard very engagingly over the course of today is an attempt to challenge the findings of fact made by the Employment Tribunal by dressing them up as points of law. A fair reading of the Employment Tribunal judgment and its reasons in my respectful submission evinces no misdirection in law. And there are one or two matters by way of clarification that I will come to shortly. If the respondent is right about that, then there is of course no basis for interfering with the Employment Tribunal's findings or indeed its conclusions. As to misdirections in law, there are one or two matters which my learned friend raised during the course of his submissions, which I think it is important that I clarify. The first of those being the respondent's position as to the law and the basis on which the Employment Tribunal ought to consider the complaint pursuant to section 111. My learned friend is right that before the Employment Tribunal, both claimant and respondent argued that the proper test was a but-for test augmented by the mental element required for direct discrimination. So that was the basis on which the case was advanced at first instance. And that was the basis in my submission upon which the tribunal reached its decision. At the point that this case was before the Employment Appeal Tribunal, I, in response to questions from the tribunal, considered the provisions of section 111 and advanced an argument, ultimately, as you will have seen, rejected by the Employment Appeal Tribunal, that what section 111 subsection 2 and 3 do is to impose a form of strict liability in relation to a person A. So just in the interests of clarity, it's right that this court is clear that at first instance, the Employment Tribunal addressed the complaint under section 111 on the basis that both parties agreed that the test was a but-for test plus the elements of direct discrimination. Having set out that matter, my submissions over the course of this afternoon at least will firstly consider the basis on which the claimant's case was put below. Because although my learned friend has suggested that it was put in a number of different ways at a high point and in an alternative way, there were some very significant positive assertions that were made on behalf of the claimant that framed and formed the findings that the tribunal made and the conclusions that they came to. And I think in fairness to the Employment Tribunal and also to properly understand the context in which the reasons were produced, one ought to look at those matters. And then having considered the tribunal reasons in the light of the way the case was put, I do propose to turn to the statutory provisions and for what it's worth, give you respondent submissions on what those provisions' proper meaning might be. I do all of those things in that order because it seems to me that as a matter of principle, an examination of whether the law has been properly applied can only be undertaken when one looks at the facts that the first instance tribunal determined. No court is required to determine the legal meaning of a provision in abstraction. Meaning is always elucidated when the court applies the law to the relevant facts that it has found. Ultimately, the respondent's submission is that the claimant below lost this case on the facts. The tribunal of first instance accepted largely the submissions made on behalf of the claimant below, but it did not accept the analysis of the evidence that was put forward on behalf of the claimant below when it came to make its findings of facts. It made different findings. My submission is that those findings were open to it on the evidence it heard, and those facts entitled the tribunal to reach the conclusion that it did. If I can briefly then turn to the way in which this case was put below, you will see, and I'm afraid we will have to take a short detour into the pleadings. Behind tab 10 of the core bundle, at page 218, the further amended particulars of claim for the claimant identify the way in which the complaint is put against the second respondent at paragraph 2D. The facts relied on in support of that claim can be seen at page 226. Sorry, not page 2, sorry, I'm sorry, page 221, paragraph 14. We see the claimant identifying, first of all, that a complaint was made from the first respondent, which she says became the focus of an investigation into the claimant. If one turns over the page, you see the claimant's assertion that having engaged fully with the investigation undertaken by Garden Court, Stonewall's complaint was upheld. And then you see in paragraph 17, the way in which the claimant initially put her case below, namely that Garden Court Chambers colluded with the first respondent, Stonewall, in the submission of the complaint against her. And indeed, the claimant went on to say that the complaint against her was procured by a member of Garden Court Chambers. And you'll see, to be fair to the claimant, at paragraph 17.
Where's procured?
My lord, we come to procure. I think it's not quite here, but it does appear. I think we'll find it in the agreed list of issues. But whilst I'm on page 222, paragraph 17C, you will see that the allegation advanced below was of an explicit and implied inducement and or instruction by Stonewall to or of Garden Court. In addition, at paragraph 18, you will see that the claimant's case below was that the Diversity Champion Programme, so the programme which framed the relationship between Garden Court and Stonewall, which was a contractual relationship, that the claimant said dictated the direction of the claim of Garden Court's
It doesn't quite say that. I follow there in the same paragraph, but the last sentence doesn't actually explicitly refer back to diversity champions.
My lord, I'm grateful and I accept that correction. What the last sentence does is to set out again the claimant's case, which
Is this the first time we get caused?
Yes, this is the first time. The way in which the respondent addressed those allegations, I think one first sees at page 256 behind tab 13. And my lord, my lady, you will see that in paragraph 3 on page 256, there is some information about the nature of the Diversity Champions programme, as it was at that time, at least. And then in paragraph 4 of this document, you will see a description of the relationship, the nature of the relationship between Stonewall and Garden Court. And you will see the acceptance that by virtue of that relationship, Stonewall was a service provider by way of the Diversity Champions programme. So in response to a question, my lord, that I think you asked earlier as to what the respondent's position was, the respondent accepted that it was a service provider to Garden Court Chambers, and for that purposes had a relevant relationship pursuant to section 111 subsection 7. If one then goes over the page, the respondent at page 257 at paragraph 8 responds to, sets out the basis of its complaint to Garden Court Chambers. I don't think for the moment I need to trouble you with the detail of that, but you will see that in setting out its position at paragraph 10, that Stonewall state that Mr. Medcalf was not a member of the team responsible for the Diversity Champions scheme, and indeed that Mr. Medcalf was not aware that Garden Court Chambers was a diversity champion at the time that his complaint was submitted. And that after, in paragraph 11, after submitting his complaint, there was no further contact between himself and Garden Court Chambers, that there was no response to the complaint provided to Stonewall by Garden Court Chambers, and the outcome only became known once these proceedings were on foot. In paragraph 12, an assertion that neither Kieran Medcalf nor anyone else at the first respondent was involved in the investigation that was carried out by Garden Court Chambers. And as it says in paragraph 12 at the foot of page 257, they were not privy to the claimant's response to that complaint, or indeed its outcome. One of the things that it may be helpful to do whilst I am inviting you to look at this document is just to take the court to page 259.
Just on your way there,
Yes.
I see it at the bottom of 258, paragraph 22. You deny that the matter is set out in paragraphs 89 to 96 of the further and best particulars.
Yes.
Do we have the further and best particulars?
We don't have the further and best particulars. I think what we have is the agreed list of issues, which ultimately
I see.
resulted.
So we don't need.
No, not strictly speaking, and it perhaps won't surprise you to hear that they are relatively lengthy because they deal with the claims against other
I think my
respondents.
lord was asking for them.
No.
But we do have the list of issues.
Yes, we have a list of issues, and I think for these purposes that is sufficient. But what one finds at page 259, paragraph 22A, is just a summary of the nature of the activities that are covered or encompassed within the Diversity Champions programme. I won't read it out, but you will see, and I will suggest, that the nature of the activities within the programme relate to advice and guidance, generally in relation to internal human resource and other matters. And the point made by Stonewall at that time was that merely by accepting the Chambers as a diversity champion, accepting it onto the scheme and offering to provide services, Stonewall was not instructing, inducing or causing any unlawful treatment.
I don't think that's suggested, is it?
It's not now alleged, my lord, but it was, and that is why I take you to some of this material, because it indicates in my submission the scope of the allegations that the claimant made against Stonewall, and the scope of the allegations, therefore, that the Employment Tribunal was required to determine. In that context, one might perhaps look rather less harshly at some of the passages in the Employment Tribunal decision and reasons. The particulars document, as I say, sets out some of the general factual responses to the claimant's case as it then stood. I'm sure that you will have read it, and I don't want to take up time this afternoon by dwelling on it for too long. What I think it might be helpful to do, though, is to take you to the list of issues, the agreed list of issues that ultimately the parties invited the tribunal to determine. And my lords, my lady, one finds that at page 190 behind tab 8. It's right at the end of the Employment Tribunal decision. I think it is probably fair comment to describe it as an unwieldy document. At page 192, however, one sees in section D the allegations against Stonewall pursuant to section 111. And again, my lord, my lady, I will leave you to read those allegations to yourselves, but one can see from a brief glance that the scope of the allegations was considerably wider than the matter which brings us here today.
We're conscious of the fact this was a pretty massive trial.
Indeed.
And 80 to 90% of which was concerned with the case against Garden Court, which succeeded.
Yes. The the way in which the claimant's case against Stonewall was framed was founded on a number of matters which it was said the tribunal would be bound to accept. I'm going to turn to those. The first of those was that the action of Mr. Metcalfe in submitting his complaint was for the purpose of supporting formal action to be taken against the claimant and not because of his perceived safety concern. That was the first specific finding that the tribunal was asked to make by the claimant's representative.
You don't mean because it's in the list of issues, you mean as matters were presented at the hearing?
Yes. The next specific finding that the tribunal was invited to make was that before submitting his complaint, and you have seen it, Mr. Metcalfe discussed that complaint with colleagues at Stonewall, including those who worked in the Diversity Champions membership team. The third specific finding that the tribunal was invited to make was that when Mr. Metcalfe submitted his complaint, he was aware that Garden Court Chambers was a diversity champion and intended that the contents of his complaint would be understood as a threat to Garden Court's position in relation to the diversity champion scheme. The fourth specific finding that the claimant invited the tribunal to make was that Kieran Metcalfe made threats in the form of his complaint to exert influence over Garden Court Chambers, drawing on the withdrawal of reputational benefit of the association with Stonewall and the infliction of reputational harm by the ending of that relationship. And fifthly, the claimant asked the tribunal to find that Mr. Metcalfe's conduct in submitting a complaint was consistent with how she said Stonewall sought to exert influence through its diversity champion scheme. And in particular, she said it was consistent with Stonewall's agenda in designating gender critical views as unacceptable, transphobic, and seeking to silence their expression. Those were, the claimant said below, specific findings which the tribunal could and should make in upholding her case against Stonewall. And the other element, perhaps not quite fully coloured in the narrative that we've had so far, was the extent of the challenge to Stonewall's witnesses and their evidence. It was a full-throttled assault on the credibility of those witnesses. What the claimant said below was that in order to appreciate the full implications of Stonewall's actions, the tribunal needed to consider the broader context of Garden Court's membership of the Diversity Champions scheme. It was said that the only possible interpretation of Mr. Metcalfe's complaint was that Garden Court should cease associating with the claimant and expel her, or there would be adverse consequences for their relationship with Stonewall. And the claimant invited the tribunal to reject Mr. Metcalfe's evidence that his complaint was about risk management and the safety of his staff, to find instead that its purpose was to complain about the claimant with a view to securing formal action against her, in particular expulsion from Garden Court chambers. Now, these are all specific matters which the claimant advanced, not just in evidence, but in submissions, and invited the tribunal to make findings about. And that, as I say, is in part the reason that we have the decision that we do have. The final matter, by way of wider context, which I think it's probably sensible to mention at this point, was the contention from the claimant that Stonewall intervened to influence how its diversity champion scheme members dealt with particular situations or with particular individuals, that it did so routinely and that it had done so in the case of this claimant. So that was the context of the complaint that Ms. Bailey brought. Those were the allegations which she addressed to the tribunal and sought to adduce evidence about. And those were matters in respect of which she sought specific findings. Having looked at the way in which the case was put, I want to just, if I may, take some time to look at the Employment Tribunal decision itself. And that is, as I know you will have found behind tab 8, you've already been taken to some of the findings of fact that the tribunal made. Perhaps helpful to note at page 93, though I'm not sure that they followed it through faithfully, an indication of the structure which the Employment Tribunal sought to impose on this decision. And you will see that at the top of the indented paragraph at paragraph 33, the tribunal deal with what it says are its findings of fact from paragraphs 34 to 249. Before dealing with the claim against Stonewall, this decision says, paragraphs 358 to 390. Of course, in the intervening paragraphs, there are findings which impact on the claims against Stonewall and other matters which are relevant to this appeal. In relation to that broader context and the way that the claimant put her case below, I think it's right that this court sees the tribunal's finding at page 105, paragraph 79, which is its conclusion about the interaction between Stonewall and Garden Court and the level of contact between them pursuant to the Diversity Champions scheme. It is clear in my submission that the contact is accurately characterised by the Employment Tribunal as minimal. And that's relevant, I say, when one comes to consider the question of inducement causing or well, we don't need to deal with instructing today.
To be fair, they say contact minimal, but they do think there's a practical advantage in having the logo.
Yes, yes. And as my lord will see when we come to it, in his evidence and in the record of his evidence, Mr. Metcalfe himself acknowledges the existence of soft power in relation to the Stonewall relationship. My lords, you've been taken to the relevant tweets and how this the investigation gets off the ground. I don't want to repeat those matters, but what you will see, if I may, at page 123, paragraph 152 of the reasons, is findings in relation to the internal decision making about how complaints generated by Ms. Bailey's tweets ought to be dealt with internally. And what one sees there before any intervention by Mr. Metcalfe or indeed anybody else in relation to Stonewall is a view within Garden Court chambers that the tweets were damaging and were affecting chambers' business. And you'll see that Ms. Hackle-Law refers to the Chamber's constitution and its provision about damaging the reputation of chambers and the consequences of that. So again, matters being canvassed well before one sees the arrival of Mr. Metcalfe or indeed anyone else in relation to Stonewall.
We're on about the 24th of October.
Yes. The tribunal found, and I think it's apparent from the chronology within the reasons, that there was an investigation to consider complaints about Ms. Bailey before the 31st of October complaint from Mr. Metcalfe. And one sees at page 129, excuse me, the judgment and reasons from paragraph 177 set out the sequence of events in terms of how that investigation went. and my learned friend has already taken you through these passages, so I don't repeat the process. In particular, my learned friend drew your attention to the initial conclusions of Ms. Sickand, who was the independent investigator, a member of Chambers, but unconnected with the issues, that her initial conclusion was that there was nothing to investigate. We come to the events as they directly concern Stonewall at page 132 and paragraph 189, where Mr. Metcalfe's complaint email is found by the tribunal to have been drafted on the 28th of October and sent on the 31st of October. Paragraph 190 sets out, and I won't rehearse it, what Mr. Metcalfe did and said. Paragraph 191, and this is, I think, material. The Employment Tribunal record that it was the claimant's case that Ms. Brewer of Garden Court Chambers colluded with Stonewall in the submission of their complaint. That's a 31st of October complaint, and or invited Stonewall to submit that complaint. Paragraph 199 the Employment Tribunal, having again rehearsed, and my friend took you through these passages, so my lords, my lady, unless you want to revisit them, I propose to push on. So at paragraph 199, the tribunal made some material findings in my submission surrounding the circumstances in which the complaint by Mr. Metcalfe was put forward. The tribunal finds that Mr. Metcalfe was present at the TOM meeting on the 23rd of October to represent Stonewall. He had never met Michelle Brewer, although he knew that she was a member of Telly, but she was not at the meeting. Mr. Metcalfe had only joined Stonewall a few weeks before the meeting and was unaware of Garden Court in general, and in particular that it was a Stonewall diversity champion. And the tribunal accept that. They say it's plausible given the long list of organisations that at that time held that status. The tribunal's findings in paragraph 199 do deal with what prompted Mr. Metcalfe to review the claimant's tweets. He says it was a message from Mr. Knarn on the 25th of October that caused him to review tweets that the claimant had put in the public domain. And having reviewed those tweets, Mr. Metcalfe decided that a complaint should be made. What one then sees, again, I don't want to take too much time on this, but at paragraph 20, we have, sorry, at paragraph 200, page 136, we can see that the tribunal reject the notion that Michelle Brewer procured complaints from Stonewall. Paragraph 202, one sees the tribunal's findings in relation to tweet number 10. In fact, tweet number 10 was a string of tweets. They concerned Stonewall, and they were posted by the claimant on the 2nd of November. And it was these tweets which the tribunal found led Ms. Sikand to comment to one of the heads of chambers that she did not think that Ms. Bailey should be maligning Stonewall, given that Garden Court Chambers was a diversity champion. My Lords, my Lady, you see that at paragraph 203. One sees how Garden Court progressed the Stonewall complaint at paragraph 205. That was a decision made by Ms. Sikand, the investigator, and it was a decision made apparently on the face of having read the complaint, but with no further input from the respondent. In terms of the chronology, then, one sees in paragraph 206 that the investigator wrote to Ms. Bailey and sought her representations on why two of the tweets that had been drawn to her attention did not breach the Bar Standards Board social media guidance and barrister duty, core duties 3, 5, and 8. In writing to the claimant, Ms. Sikand identified particularly the comments that she wanted, the tweets that she wanted comments on. It was not all of them, it was 2 of them, and you will have seen at the foot of page 137, paragraph 207, that one of those was the Morgan Page tweet. You've been taken to, at least in passing, the way in which Ms. Bailey responded to Ms. Sikand and set out her response to the allegations that her conduct may cause her to be in breach of core duties and or any guidance that had been provided. What is clear at page 141, paragraph 218, is that the claimant was saying in terms that her rights to freedom of expression were being interfered with by reason of the Stonewall complaint. And she made it clear in the tribunal, find this at paragraph 218, that in the claimant's view, the tone of Stonewall's complaint made it clear that they thought they had entered into a quid pro quo with Chambers and that Chambers would do the right thing and sack her. In paragraph 219, the claimant develops that theme, for want of a better expression, in describing Stonewall's complaint as a third-party attempt to harass her. What one sees at the foot of page 141, at paragraph 221, was the tribunal's finding of the initial response of Ms. Sikand to the complaint from Stonewall and the claimant's rebuttal. And she notes that the language of the response was both highly provocative and emotive throughout. The assertions are sometimes inaccurate and on a very quick read appear to accuse Garden Court Chambers of harassment for accepting the complaint. Faced with the Stonewall complaint and with the claimant's front-footed rebuttal, Garden Court Chambers decided to approach the Bar Council Ethics Committee for advice, in particular on the social media guidance, but also, as you have seen and read, the components of the core duties and the extent to which those might have been engaged. That decision to consult with the Bar Council Ethics Committee was again a decision taken entirely by Stonewall, by Garden Court's internal management. And again, I don't need to labour the point. The tribunal decision sets out the steps that then happened in terms of providing Ms. McGarhy with information, making decisions about what material it was and was not appropriate to share with her, and the view that Ms. McGarhy expressed in light of the material that she had been shown. Again, none of those matters were matters which Stonewall was invited to or did engage with. And one sees at the top of page 144 at paragraph 229, the response of the heads of chambers and Ms. Harrison, who were pleased with the report, the provisional report as it was then, and that as a result, one of the heads of chambers decided there was no need for any further advice from the Bar Council Ethics Committee, because the conclusion which they all agreed with was that there was no further action required in terms of regulatory reporting. Pages 144 from paragraph 230, right the way through to paragraph 236, sets out the steps which occurred and which led to the production of the final report in relation to the Stonewall complaint. Again, none of those provisional documents, draft documents, or indeed the completed report were provided to Stonewall or to Mr. Metcalfe. The report was not distributed within chambers either, or sent to any other complainant. And as the tribunal later discussed, Mr. Metcalfe became aware of the outcome only as a result of these proceedings. The outcome in terms of the Garden Court internal investigation was to conclude that 2 of her tweets were likely to have breached bar standard core duties 3 and 5. And she was asked to delete them. Ms. Bailey replied, I think on the 20th of December, that she was, having considered the report, she was not minded to delete tweets, and she did not. And that was the end of it. So when one looks at the chronology and one identifies the points at which Stonewall was involved in a meaningful sense with any of this, one sees an emailed complaint sent on the 31st of October and nothing more. Since I'm inviting you to look at the tribunal decision, I would like to ask you to see how the tribunal approached the question of identifying the relevant law and applying it to the facts that it had found up until paragraph 249. In my submission, what one sees is a an unremarkable series of self-directions on the law from pages 250 through to, paragraph 250 through to paragraph 259. And those authorities and the principles to be derived from them were matters of essentially common ground between the parties. There is a lengthy passage, I'm not going to trouble this court with it, in which the tribunal deal with the claimant's belief and the discussion around the extent to which those beliefs were protected. As my learned friend says, there has been no appeal in respect of that finding, and so I don't propose to touch on it now. What I do think it's important to take you to, however, is to some of the other allegations that were in play at the time, made by Ms. Bailey as against Stonewall. And in particular, and will have perhaps picked it up from the agreed list of issues, there was an allegation of indirect discrimination made against Stonewall. And that allegation is relevant in my submission because the provision, criterion or practice that was said to have been applied was that the second and third respondents, so Garden Court Chambers, allowed Stonewall to direct its complaint process. So there was evidence in relation to that matter, which necessarily involved witnesses from both Garden Court and Stonewall, and of course the tribunal had evidence from Ms. Bailey. What one sees, excuse me, in the reasons is the tribunal mulling over the evidence that it had received, and at page 179, page 355, one sees the conclusions that the tribunal drew from that evidence. And again, it's my submission that these findings are relevant in the context of the allegations that are made pursuant to section 111. I don't think I overstate the position if I describe the tribunal's conclusions in relation to the suggestion that Stonewall directed the investigation process as being emphatic and material. Tribunal say in terms in paragraph 355 that there was no evidence that Stonewall directed how the complaint was handled. Tribunal note that there was no evidence that Stonewall followed it up or even asked the outcome. And they make a number of points which they say support the finding that they have made. And again, for the avoidance of doubt at paragraph 356, page 180, they make it clear that there is the claim in relation to Stonewall and its alleged indirect discriminatory treatment was not made out. And then finally, we come to the only place in the tribunal reasons where the tribunal direct its specific attention to the complaint made against Stonewall pursuant to section 111. The other allegations arose in different contexts, but here we have the tribunal looking at the relevant statutory provisions and considering matters in some detail. The starting point, if I can venture this, always a good sign, the words of the statute. And in paragraph 359, the Employment Tribunal set out how it understands that applies to the parties in front of them.
Yes.
You will see paragraph 360, and this I think is in part a response to the point my learned friend has made, where that one doesn't really know what test the tribunal were applying, and it's all very confusing. The tribunal tell you at paragraph 360 the test that they apply in relation to direct discrimination, and it's the test that he invited them to apply, and which the respondent did not demur from.
So the tribunal must find that the reason or the reasons were significantly influenced by the protected characteristics.
And the caution which was articulated earlier on today about not confusing motive with reason in this context, set out in paragraph 360.
It's like grammatical, which
Yes.
you can get the gist of it.
I am not proposing to defend the grammar,
Yeah, it's all right.
but I think in terms of the meaning, and certainly in response to the suggestion that one doesn't know what test the tribunal were applying, one has a response, one has an answer to that.
So you say they were applying the test of
I
was-
wonder whether reason should mean actions.
I'm sorry, I just didn't catch the last.
Should it be the tribunal must find A's action
Yes,
for its instruction,
Yes.
inducement, blah blah.
yes.
Significant influence. Even if motive.
Yes.
they were looking for a significant influence
Yes.
from protected characteristics.
Yes. And then in relation to the intricacies of section 111, in paragraph 361, they navigate their way through subsection 5 and identify from that it does not matter whether or not a basic contravention in fact occurs. So they have that point. And the tribunal narrow their focus in 361 by focusing on the detriments that could conceivably have resulted from the complaint email, recognising, as the parties did below, that some of them could not have been caused by the complaint because they predated it. The tribunal also, in paragraph 362, had regard to the case of NHS Development Authority and Sega, which was before them, and the proposition for which it was it was produced is set out there, namely that it is not enough to show that individuals were in a position to instruct, cause or induce. There must be actual evidence that there has been instruction causing or inducement or an attempt to do those things. And then in paragraph 363, one sees the appropriate direction in relation to the burden of proof. And again, in paragraph 364, one sees the tribunal reminding itself, in the light of, as we have already observed, the relatively numerous allegations that it had been charged with determining, what the conduct what conduct the claimant relied upon for the purposes of her section 111 complaint. And they group them there in paragraph 364. And you will see that amongst the many things done, the response to the complaint to Garden Court from Mr. Metcalfe is the final item in paragraph 364. So
Yes.
clear that at this stage, at least, the tribunal has its eye fairly firmly on the relevant law, fairly firmly on the disputed facts, and then it proceeds to make some findings about those things. In paragraph 365, there are some material findings. That, firstly, the respondent was not aware of the claimant's internal Garden Court email suggesting that being a diversity champion was not a good idea for a range of reasons. The tribunal also make a finding about which individuals Stonewall dealt with at Garden Court. They say that the only individuals dealt with at Garden Court by Stonewall who had anything to do with decisions that that Garden Court made about the response to the claimant's treat were David de Menezes, who was the responsible for marketing and who set up the scheme with Garden Court, and Mia Hackle-Law, who corresponded with Stonewall about the Garden Court's employment policies when they took up the offer of a review of their employment policies and procedures. But the tribunal make the point that neither made decisions, although they contributed to the internal debate with the heads of chambers on what to do. The other, I think, material finding in 365 is that Stonewall had, up to that point, we are now 31st of October, had done nothing to suggest that any work would be directed to Garden Court or that there would be any naming and shaming of Garden Court for their views or associations. That was something that the tribunal took time to state clearly in paragraph 365. It also notes that, perhaps unsurprisingly, the marketing director was concerned about damage to the Garden Court brand, but nothing that Stonewall had said or done served to give him that impression. The other matter which is dealt with in paragraph 365 tackles the way in which the claimant had described the diversity champion scheme. She had characterised it as an organised protection racket, and that was a description which was articulated on a number of occasions during the course of her evidence, and the tribunal expressly find that that was not the case. A reiteration, I think, in paragraph 366 that Ms. Brewer was not a mouthpiece for Stonewall, and the tribunal are at pains to set out the extent of her connection with Stonewall. And then in paragraph 367, excuse me, the tribunal turned to Mr. Metcalfe's specific complaint. You've read it for yourselves. I don't think at this point in the day it's necessary for me to invite you to reread it. But what one sees in paragraph 367 are the matters which, in particular, the tribunal drew from Mr. Metcalfe's complaint on behalf of Stonewall. In paragraph 368, the tribunal consider the purpose of the complaint. And again, it's worth reminding ourselves that they are considering the purpose of the complaint, in part because the claimant has positively asserted that the purpose of the complaint was to harass her and to elicit her removal from chambers. So, not unreasonably in my submission, the tribunal spends some time considering that matter and looking to see what evidence there was that either tended to support it or to undermine it. And we see in paragraph 368 some of their conclusions. And in my submission, what one sees in paragraph 368 is an acknowledgement that Mr. Metcalfe's email could be read in more than one way. The tribunal say that the statement that continued association with Ms. Bailey put Stonewall in a difficult position. The claimant's suggestion that was a threat that she should be expelled if Stonewall was to continue its relationship with Garden Court. Tribunal say that's certainly one reading. And then they record what Mr. Metcalfe said about his email and what its purpose was and what he said in it. And you will note the tribunal's observation that his explanation was not clear from his email, but they thought it was consistent with that part of his email which said that he wrote as a protest about Stonewall staff being targeted with transphobic abuse on a public platform, and the concern expressed in the email about safety of Stonewall staff and communities. What is clear in paragraph 368 is that the tribunal takes some time to set out Mr. Metcalfe's response to the challenges about why he wrote the email and what he was hoping to achieve. And the reason why he was asked questions about that was because, at first instance, the claimant thought it was important to establish that Mr. Metcalfe was acting on behalf of Stonewall and was acting explicitly because of her protected belief. There is, in my submission, no doubt that the tribunal understood that that was the way in which the claimant put her case. And what they do in paragraph 368 is to record Mr. Metcalfe's response to that case and his justification, for want of a better word, for doing what he did in the way that he did it. And we come then to the view that the tribunal took of Mr. Metcalfe's evidence, because the claimant's submission below was that it was patently not credible, shouldn't be believed, and ought to be dismissed out of hand. Well, that was not the view that the tribunal took. And it's also clear from paragraph 369 that the tribunal themselves asked Mr. Metcalfe about his email in an attempt to understand what precisely was going on. Ultimately, the tribunal did not agree with Ms. Bailey's characterisation of Mr. Metcalfe's actions and the reasons for his actions. That is, that the tribunal preferred evidence from Mr. Metcalfe to her evidence, that Mr. Metcalfe was determined to have her expelled from chambers because she was a Stonewall target.
On 369,
Yes,
I asked Mr. Cooper this as well.
yes.
But there's this commentary on what the tribunal thinks that Mr. Metcalfe wanted to achieve, writing to protest about her views,
Yes.
stated to come from the Garden Court, and you wanted to put the case for transgendered people. In
Yes.
other words, he wrote without any specific aim in mind, except perhaps a public denial of association with her views. Now, Mr. Cooper says that's undoubtedly the tribunal finding that he wanted Garden Court publicly to deny association with her views. And I just put to you the same question I put to him as, can it be read a different way, is that he was putting on record his denial of association with her views. So how does one read that?
My lady, that is how I would read that part of paragraph 369, not least because what the tribunal firstly do is to record what it is Mr. Metcalfe said, namely that he had his advocacy hat on. What follows from that is not what he said, but what they drew from what he said, which was both about writing to protest about her views and to put the case for transgender people, that being part of his role with his advocacy hat on. In that context, I don't think it's right to read paragraph 369 as a finding that Mr. Metcalfe was acting to protest against the claimant's protected belief. To say that he wrote without any specific aim in mind is qualified by the except perhaps a public denial of association with her views. That is the tribunal's conclusion.
But whose public denial? Is it him saying, I want publicly to deny this, or is it an invitation to Garden Court saying, please can you publicly deny association with
No, in keeping with Mr. Metcalfe having his advocacy hat on, it is Mr. Metcalfe saying, I can't be associated with this.
I assume we obviously can't at this moment, but I assume no one can find out the answer just by looking at a transcript.
No. Well, I say no. I don't think we have a transcript.
No.
Certainly, I don't have a transcript.
There's no transcript. We have notes of the evidence which we can look back to, see if that will help.
This is a finding, and we'll have to make of it what we will, but I just wanted to put the contrary case and just see where that shook down.
Yes, I'm sorry, I probably can't be of any greater assistance on paragraph 369, I'm afraid.
But it's not suggested that 369 is a false record of what he said. The question of
what it meant.
That's yes, that's what the tape recording would show you.
Yes.
But I don't think we need that.
No.
That's what he said. The question is the findings that they drew.
Yes.
From that.
Except, I mean, this is a summary of what he said. It may be that actually, if you see the question and answer or the notes of the question and answer, it's apparent what he meant.
I think it would be remiss of me to say anything further. I will go and look at my note and if
And it may well be
sheds
a
any light on
forlorn,
that. Yes.
exercise.
But I'm not going to pretend that I can recall the sort of intricacies of that exchange.
Well, if both sides have a note which indicate that something material is left out,
Yes.
and you both agree that we
Yes. should
see it, of course we'll see it. But absent agreement, I think we ought to stick with what we've got.
Yes. Thank you. Just in relation to the further question that was asked about paragraph 369, it is my submission that what we have for better or for worse at paragraph 369 is the Employment Tribunal's findings of fact. What is recorded there is what they heard and accepted and what they drew from it. And I cannot see on what basis one could go behind it. one simply has in my submission to try and make sense of it.
That's the difficulty. It's not
That's the
quite clear what
difficulty.
it
Yes,
means.
indeed. But certainly there is nothing in the decision that precedes this or follows it, which suggests that it's a finding that wasn't open to them to make. And therefore, I think, for my part, I will have to try and embrace it in the balance of my submissions. If I may just get to the end of this passage, paragraphs 370 to 374, one sees some of the factors that the Employment Tribunal took into consideration in reaching their conclusions. Again, my general submission is that whilst it's not suggested that any of these matters were determinative, they were all factors which the Employment Tribunal was entitled to have regard to. The weight, if any, to be placed on these matters was absolutely a matter for them. Those considerations led the tribunal to the point where they were satisfied, and we see this at page 183, paragraph 372, that Kieran Metcalfe and Stonewall had not in fact been looking for any action. It was just a protest. So one has a move from the earlier passage at paragraph 369, page 182, to a finding that Kieran Metcalfe and Stonewall had not in fact been looking for any action in relation to Garden Court.
So sorry, you say that's a finding, do you?
Yes.
And if that's to be consistent, then that answers the question, doesn't
Yes.
it, on
page
369
269.
about what he wanted. Yeah.
And I think perhaps what we have is in this document is full disclosure of the ruminations that the tribunal undertook in arriving at its considered view on various matters. But in my submission, we do get their considered view. And in the balance of 372 to 375, we see the tribunal trying to deal with the many and varied submissions that were made to it, both about what they should and should not take into account, what they had and hadn't seen. We see in paragraph 373 a passage which perhaps sheds some light on the tribunal's thinking about the particular subsections of 111. You'll see midway through paragraph 373 there is some reference to whether the email that Mr. Metcalfe sent contained an instruction, and they say it did not. And if there was an inducement, and it identifies the kind of inducement it was looking for, it says that lay in the minds of Garden Court managers and heads. It did not come from Stonewall. And in terms, in my submission, it's not an inducement if it's not from Stonewall.
I understand that. The previous sentence or part sentence, line 6, does seem very odd. It was Stonewall that stood to lose. If
I'm sorry, can I just find the...
Yes, 373, line 6.
It was Stonewall that stood to lose.
Garden
Yes.
Court provided voluntary services to
Yes.
Stonewall, not Stonewall to Garden Court. It was Stonewall that stood to lose. Really?
Yes. So
If it's supposed that diversity champion status had been withdrawn and this had been public, that would have been a loss to Garden Court, wouldn't it?
Well,
We're not talking about a cleaning contract or something like this. This is a contract which, as they put elsewhere in a passage which we've been shown, it's a valuable asset to Chambers to be able to put the Diversity Champion logo on their neck paper or e-neck paper.
my lord, yes, I'm not sure I would go so far as to describe it as a valuable asset, but it was certainly one of the benefits of membership of the scheme. What it, in my submission, that part of paragraph 373 is getting at is that the TON meetings were being held in premises donated by Garden Court for the benefit not just of Stonewall but of all of the organisations that participated, and that if Mr. Metcalfe or in particular or Stonewall in general decided that those meetings could no longer take place at Garden Court, then it was Stonewall who would suffer the immediate disadvantage because they would have to find another location. I think that's all that paragraph, that sentence.
I'm looking for it and of course can't find
Yes.
it. I thought there was another passage in this quite long decision
Yes.
where, and this is my take on it,
Yes.
this is not what they look at the arrangements between Stonewall and Garden Court, and it's a sort of package.
Yes.
And then they have the piece where they say, in fact, Stonewall never really came up
Yes.
with the things that they said they'd provide. But
Yes.
It was always jam tomorrow. And it ended up with Garden Court doing a lot of the bit that it had promised to do.
Yes.
But it wasn't quite the deal that anybody envisaged. That's what I understood that to say.
Yes, and yes, that there is a passage which specifically where that's specifically dealt with, so I can find it. The other point to make, my lord, since you drew it to my attention, is that the idea that the Diversity Champion Scheme membership could be terminated, the tribunal dealt with a little bit later on in this on this page, having looked at the agreement which the parties signed. There was in fact no provision for termination. So the notion of withdrawal of membership, which was put to Stonewall witnesses and was met with some bemusement because, as they said, membership of the scheme is supposed to be a supportive piece. Organisations are at different stages in their journey towards inclusiveness, and therefore it is not a relationship that would terminate other than upon the expiry of the term, and membership was a 12-month membership.
And you paid by the year.
Yes, exactly.
You paid your fee or you
Yeah.
didn't pay.
And as happened in this case, I think it was 2020, they didn't pay, and so they ceased to be members of the scheme. With I'm not sure.
Do we know when that was?
It's
They've been in it for
20.
2 years.
Yes,
haven't they?
it's 2020, the beginning of 2020. I just find it. I think it was.
Well, not to worry.
No, that's not.
Are we reaching a convenient point to break off?
Well, yes, now is
Should we do that?
convenient. Thank you very much.
All right.